Your Honor, if this matter proceeded to trial, the proof would be that on April the 7th of 2024, the defendant was at Chief's Bar and Restaurant located at 200 Broadway Avenue. The defendant was on the 6th floor of the rooftop bar. The defendant picked up a chair, threw it off the 6th floor. The chair landed on Broadway approximately 3 feet from where officers Gavin, Treese, and officer Yurislav, Holikov were standing, placing them in imminent danger of death or serious bodily injury. All these events happened in Nashville, Davidson County, and based on those facts, the state would recommend the previously announced agreement. And Your Honor, I'd like to say that officers Gavin, Treese, and officer Holikov were both consulted about this plea and both approved it.
You are waiving your right to have your case presented to the Davidson County Grand Jury, is that right?
Yes, ma'am.
All right. You were charged in case 2024 I-687 with 2 counts of misdemeanor reckless endangerment. Mr. Wallen, did you hear the facts as read by the Assistant District Attorney?
I did hear that.
Are those facts true and correct?
Substantially, yes.
Are you waiving your right here today and entering a plea of guilty in your pending case?
Conditionally guilty, yes.
Conditionally guilty, yes, ma'am.
In case number 2024 I-687, where you were charged with 2 counts of reckless endangerment, how do you plead, sir?
Conditionally guilty.
All right. Mr. Robinson, anything further? On the other hand, if you do not successfully complete your probation or you have other arrests or trouble with the law, you run the risk of losing your judicial diversion status. And if that happened, these offenses convert to convictions on your record. Do you understand that, sir?
I understand.
You understand you're charged with more than 1 count, and I want to make sure you understand if you were convicted of 2 counts, you would receive a separate sentence for each of those counts. Do you understand that?
Yes, ma'am.
I understand. Do you understand what it takes under the law to be found guilty of what you're charged with, sir?
Yes, ma'am.
I understand that you are entering a plea of guilty to 2 counts of reckless endangerment. You will receive a sentence of 11 months and 29 days, all suspended except 7 days incarceration, which will be served at a DUI education center. The remainder of that sentence will be served on supervised probation. These counts run consecutive to each other, that is, one after the other, for an effective sentence of 2 years. And the sentence is pursuant to judicial diversion, which we will talk about a little bit later. Is this your understanding, sir, of what you're pleading guilty to and the punishment being imposed?
Yes, Your Honor. We talked about the formal conditional guilty plea, but yes, he understands that.
All right, but those are the offenses that he understands he's pleading guilty to and the sentence, which is a 2-year sentence.
Yes, ma'am.
All right.
Morgan, how are you feeling?